I had spent almost 3 years planning my dream house, and by the time the first walls went up, I had already dealt with more paperwork than I ever wanted to see again. There were architectural plans, engineering reports, permits, contractor agreements, soil tests, inspections, financing documents, and dozens of emails with the HOA Architectural Committee. I knew exactly how frustrating the process could be, but I accepted it because I wanted the house to be perfect. The property was inside a large HOA community, which meant I understood that there were rules. I expected restrictions on exterior colors, landscaping, fences, roofing materials, and other visible features. What I didn't expect was that after approving my plans, the HOA would suddenly decide that my entire house needed to be demolished. The first sign of trouble came when I received a letter saying construction had been suspended. The letter claimed that the house did not conform to the community's architectural standards. I immediately called the HOA and reminded them that their architectural committee had approved my plans months earlier. The woman on the phone told me that the previous approval had been issued based on incomplete information. I asked what information was missing. She couldn't explain. I asked whether there was a specific violation. She said the house was inconsistent with the character of the neighborhood. That wasn't a rule, it was an opinion. I contacted my architect, who pulled up the original approval email and stamped plans. Everything matched what we were building. The setbacks were correct. The height was correct. The exterior materials were exactly what had been approved. My contractor told me he had never seen an HOA attempt to stop a permitted project at this stage. Then the HOA president appeared at the construction site. She arrived in an SUV with 2 board members and stood outside the temporary construction fence. She told my workers to stop immediately. My contractor asked whether she had a court order. She said she didn't need one because the HOA had authority under the covenants. My contractor told her that the county permit was active and that he could not simply abandon the project based on a verbal demand from an HOA representative. She became angry. She told him that if he continued, the HOA would fine me every day. I walked over and asked her to identify the exact covenant provision that prohibited the house. She pulled out a binder. She flipped through several pages. Then she pointed to a section about architectural control. I read it carefully. The section gave the HOA authority to review exterior design, but it did not say the HOA could cancel a previously approved project simply because the board changed its opinion. I told her that if she believed I had violated a specific rule, she needed to put it in writing. 2 days later, I received another letter. This time it was much more serious. The HOA demanded that I either redesign the house or remove the unauthorized structure. The word remove stood out. They weren't asking me to change a window. They were talking about tearing down the house. My attorney immediately requested the HOA's complete architectural records. We wanted to know exactly what had happened. The HOA delayed providing them. Meanwhile, construction continued because the county permit was still valid. Then the HOA contacted the county. They claimed the house violated building requirements. That turned out to be their biggest mistake. A county building inspector arrived at the site the following week. The HOA president was there waiting for him. She immediately began explaining that the house was too large, too tall, and allegedly too close to the road. The inspector listened without interrupting. Then he walked around the property with a measuring device. He checked the approved plans. He inspected the foundation and framing. He reviewed the permit history. After nearly an hour, he turned to the HOA president. "What county code violation are you alleging?" She said the house violated community standards. He repeated the question. "What county code violation?" She couldn't answer. The inspector explained that HOA rules and county building codes were different matters. He wasn't there to decide whether the HOA liked the house. He was there to determine whether the construction violated county requirements. He checked the measurements. Everything was within the approved plans. He checked the permit. It was valid. He checked previous inspections. They had all passed. Then he asked the HOA president whether the association had a legal order stopping construction. She didn't. The inspector told everyone that unless the county issued a stop work order for an actual code violation, construction could continue. The HOA president was furious. She accused the county of interfering with private community rules. The inspector calmly told her that the county wasn't interfering with anything. It was simply enforcing the law within its jurisdiction. The HOA wasn't finished. A week later, they sent me another notice demanding demolition. This time my attorney responded. He requested the exact recorded covenant provision supporting the demand. The HOA produced a document that supposedly contained an architectural restriction. My attorney compared it to the recorded covenants. The wording was different. Someone had inserted additional language into the HOA's internal copy that did not appear in the county's official record. We obtained certified copies of the original covenants. The alleged demolition authority simply wasn't there. The HOA had apparently been relying on an internal document that was not the same as the recorded declaration. That discovery completely changed the legal situation. My attorney filed a complaint and requested an injunction preventing the HOA from interfering with construction. The court reviewed the original covenants, architectural approval, county permit, inspection records, and HOA correspondence. The HOA argued that it had broad architectural authority. The judge agreed that the HOA had some authority. But authority had limits. The HOA couldn't invent restrictions that weren't recorded. It couldn't cancel a valid approval simply because a new board disliked the design. And it couldn't order demolition of a permitted structure without a valid legal basis. The court stopped the HOA from interfering with the construction. Construction resumed. Months later, the house was completed. I remember standing in the unfinished living room one evening while the sun came through the enormous windows. I thought about how close I had come to losing everything I had invested in the project. The HOA president never apologized. But something else happened. Other homeowners began reviewing their own approval records. Several discovered that the HOA had threatened them using provisions that weren't clearly supported by the recorded covenants. The board eventually replaced its management company. My house became one of the most recognizable properties in the neighborhood. The same people who had called it an eyesore eventually stopped complaining. But I never forgot the lesson. The HOA had tried to make me believe that their letter was more powerful than my permit, more powerful than the county records, and more powerful than the actual covenants. It wasn't. A threat may look official when it arrives on expensive letterhead, but when the documents are placed side by side, the truth usually becomes much easier to see.